Having learned the historical purpose and core elements of the 1967 Arizona Consumer Fraud Protection Act, we now turn our attention to how this important consumer protection law directly applies to real estate transactions. Real estate, unlike many other forms of merchandise, represents one of the most significant financial investments most individuals will make in their lifetime. Because of this, Arizona law imposes strict expectations of honesty, accuracy, and transparency upon all parties involved in real estate dealings. The Consumer Fraud Protection Act, CFPA, codified under ARS Section 44-1521 through Section 44-1534, specifically defines merchandise to include real property, ensuring that real estate professionals, developers, builders, and sellers are all accountable for truthful advertising, representation, and disclosure. The CFPA applies broadly to any act in connection with the sale or advertisement of merchandise, which encompasses nearly every aspect of a real estate transaction. From the initial listing to closing, the key provision, ARS Section 44-1522A, makes it unlawful to use deception, false promises, misrepresentation, or concealment of material facts with the intent that others rely on such conduct. This language captures not only overtly false statements, but also omissions, failing to disclose information that would influence a buyer's decision. This broad reach means that real estate licensees, brokers, developers, and even unlicensed individuals involved in real estate sales are bound by the Act's standards. Consider a scenario in which a broker advertises a commercial property as zoned for multifamily development without verifying the zoning classification. If a buyer later discovers that the property is zoned for single-family residential use only, this misrepresentation, even if unintentional, could constitute consumer fraud under ARS Section 44-1522. Another example involves a home seller concealing a known foundation defect while claiming the home is in excellent condition. Even if the defect is minor, the concealment of a material fact is sufficient to trigger liability under the Act. These examples highlight the principle that truthfulness and transparency are non-negotiable in real estate advertising and sales. The Arizona courts have consistently reinforced the application of the CFPA to real estate. In State ex R.L. Babbitt v. Goodyear Tire and Rubber Company, 1974, the Arizona Supreme Court made clear that the law should be interpreted liberally to protect consumers from any unfair or deceptive act. Later, in Dunlap versus Jimmy GMC of Tucson, Inc., 1984, the court affirmed that even omissions of material facts, such as failing to disclose an adverse condition, could amount to fraud. Translating this principle into real estate, the failure to disclose known issues, such as roof leaks, prior termite damage, or neighborhood nuisances, may expose a seller or licensee to liability under both the CFPA and ARS Section 32-2153, which prohibits dishonest and fraudulent conduct in real estate transactions. Real estate licensees are also governed by the Arizona Department of Real Estate, ADRE, and must comply with Commissioner's Rule R4-28-1101, which outlines professional standards of practice. This rule requires that all licensees protect and promote the client's interests while being honest and truthful to all parties. When a licensee violates this rule by exaggerating property features, making false claims about market conditions, or withholding important information, they are not only breaching professional ethics, but also violating the CFPA, the ADRE, and the Arizona Attorney General's Office work cooperatively to investigate and enforce such violations when they involve deceptive conduct affecting consumers. One of the most common applications of the CFPA in real estate involves misrepresentation in advertising. Under R4-28-502, all advertising must be truthful, not misleading, and clearly identify the employing broker. If a licensee markets a property as having mountain views when the view is obstructed, or describes a property as brand new when it was built several years prior, those statements could qualify as deceptive advertising under both the Commissioner's Rule and the Consumer Fraud Act. Furthermore, misleading online listings or social media promotions, such as digitally altering images to conceal defects or misstate features, may also constitute consumer fraud. Another key area involves property disclosures. Arizona law requires sellers and agents to disclose all material facts about a property that could affect its value or desirability. Failure to disclose known issues, such as previous water damage, flood risk, or unpermitted additions, is a direct violation of the CFPA. For instance, if a licensee knows a property has a history of roof leaks, but chooses to omit that fact from the Seller Property Disclosure Statement, SPDS, to secure a sale, that omission is considered concealment of a material fact under ARS Section 44-1522. The courts have routinely found such omissions to be fraudulent, even if the buyer later discovers the issue before closing. The CFPA also applies to investment property transactions, where buyers often rely heavily on financial representations. A broker or developer who provides falsified income statements, inflated occupancy rates, or misleading cap rate calculations could be prosecuted for consumer fraud. The law's broad wording ensures that whether the misrepresentation involves physical property conditions or financial performance, the conduct is treated equally under the law. This underscores that the CFPA protects not only residential homebuyers, but also investors and commercial clients. Another important dimension of the Act's application involves subdivision sales and land promotions. Under ARS Section 32-2181, developers must obtain a public report before selling subdivided land. If a developer markets land before this approval is issued or misrepresents its readiness for construction, they violate both Title 32 and the Consumer Fraud Protection Act. The dual violation underscores Arizona's commitment to transparency in real estate development, ensuring that every buyer receives accurate and complete information before making a financial commitment. Enforcement of the CFPA within real estate is primarily managed by the Arizona Attorney General, who has authority under ARS Section 44-1524 to investigate deceptive sales practices. In serious cases involving licensed professionals, the Attorney General may coordinate with the ADRE to impose additional disciplinary actions, such as license suspension or revocation, under ARS Section 322153. Penalties can include civil fines, restitution to injured parties, and injunctive relief, preventing the offender from continuing similar practices. The cooperation between the Attorney General's office and ADRE ensures that both consumer justice and professional accountability are maintained. Review summary. The Arizona Consumer Fraud Protection Act applies directly to real estate transactions by prohibiting deceptive or misleading practices in the sale or advertisement of property under ARS Section 44-1522. It is illegal to make false promises, misrepresentations, or conceal material facts, even if no actual harm results. The law applies to licensees, sellers, developers, and any party involved in marketing or selling real property. It reinforces the professional obligations set forth under ARS Section 322153 and Commissioner's Rule R42-81101, ensuring that real estate professionals act with honesty, accuracy, and full disclosure. Enforcement by the Arizona Attorney General and the ADRE protects consumers from fraud and maintains public trust in the real estate industry. Discussion: why is real estate included under the Arizona Consumer Fraud Protection Act? Answer: because the Act defines merchandise to include real property, meaning that all representations, advertisements, and sales involving real estate are subject to its protections. What types of actions in real estate could violate the Consumer Fraud Protection Act? Answer: false advertising, omission of material facts, exaggerating property conditions, concealing defects, or misrepresenting zoning, income potential, or approvals. Does a buyer need to prove financial loss to bring a claim under the Act? Answer: no. Under ARS Section 44-1522, it is enough to show that the conduct was deceptive or misleading. Even if no one suffered monetary harm, who enforces violations of the Consumer Fraud Protection Act related to real estate? Answer: the Arizona Attorney General's Office, often in coordination with the Arizona Department of Real Estate. How do the CFPA and Title 32 real estate laws work together? Answer: the CFPA addresses deceptive conduct broadly, while Title 32 regulates professional standards. Violations often fall under both. Allowing enforcement by the Attorney General and Audrey closing remarks, the Arizona Consumer Fraud Protection Act stands as a powerful reminder that the real estate profession is built on trust. Every representation, disclosure, and advertisement must reflect truth and integrity. By applying the principles of the CFPA to their daily practice, real estate professionals not only comply with the law, but also uphold the ethical foundation of the industry. This law bridges consumer protection and professional responsibility, ensuring that every transaction in Arizona real estate is conducted transparently and honestly. Understanding the Act's application empowers licensees to prevent liability, serve clients ethically, and contribute to the long-standing integrity of Arizona's housing market.